5 days since Raila Odinga bundled up that 24-page petition and 12 supporting affidavits and filed his petition at the Supreme Court. The 7 judges of the court now remain with just 9 days to determine the outcome of this petition. We have all the updates on the case and the details of the intrigues outside the court. But first of all, let's look at the highlights. Leave it to the judges. Supreme Court warning of a presidential petition. Race against time. Deadline looms for respondents to answer to NASA's petition. And judges prepare for the pre-trial conference as clerks finalize the summary of the petition. All right, later on I'll be speaking to my colleague Sophia Wanuna, who is on this case with me, and she's somewhere in our city center studios, and I'll be going to her in a few moments. But let me first of all introduce my panel here, and it's day 2 here with Kakai Kissinger. You know him by now, and of course Dr. Linda Musumba, who is a senior lecturer at Kenyatta University School of Law there. And we are going to be looking at different aspects of this and the historical perspective. Yesterday we were looking at the 2013 petition, ladies and gentlemen. And by the way, we'll be joined by Bobby Mkangi later on. He was part of the COE. Probably we'll ask him a few things that they had in mind with this constitution. But let's look at what we've been dealing with. 2013 was the first time ever that a petition, a presidential petition, went through a full hearing. There had been many tests before. How is it that from the time of Matiba and Mwao and Kibaki and all this, we had never had a petition being had? In fact, 2013 was kind of surreal to many Kenyans, like, wow, we actually have a presidential petition going on at the courts. What changed?
Joe, of course, before 2013, we did have presidential candidates filing election petitions. We had Matiba, we had Mwao, but these were dismissed on very, very, what today one would call flimsy grounds, but nonetheless that existed then, including, for example, a presidential candidate not signing the petition.
Like in Matiba's case.
Yes, in Matiba's case. Yeah. And then in Mwao's case, we had, of course, the non-compliance of his petition.
The size of the foolscap.
With the size of the foolscap, yes.
Yeah. An interesting gentleman, actually, and he insisted on sort of representing himself in everything.
Sure. So in 2013, of course, with the promulgation of the 2010 Constitution, you have a situation where technicalities were flagged up as something that should not prevent the course of justice. And so you find that many of those things that would have removed or obviated, you know, the presidential election petitions from proceeding have been removed under the 2010 Constitution and going forward.
All right, Kakai, I'll come to you in a moment, but I need to go to my colleague Sophia Wanuna, who is at the City Center studios. And Sophia, a lot of things happening at the Supreme Court, I would imagine, this entire week. And today, quite some stringent, I would say, directions coming from the Supreme Court. Are we going to be arrested tonight?
I don't think so, Joe. Good evening to you. Yes, that directive coming from the Supreme Court. And of course, it is the one that is directed first are the parties involved in this petition. And the Supreme Court is asking that they desist from discussing the matter. And they're citing that sub judice rule, which in essence talks about when a matter is seized of a court, then parties involved should not discuss the same. The media as well, as you mentioned there, do we risk arrest? I don't think so, because we're not getting into the merits or demerits of the matter before court, but also the media, they're getting caution, and every other person. Really, the Supreme Court saying we have the matter with us and we will deal with it according to the law, and let everybody else, including supporters, agents that notice from the Supreme Court said should desist from talking about this matter, asking the lawyers involved to guide their clients in as far as the consequences they could face if they do so.
All right, Sophia, and where are we on the timeline right now? There is a 14-day period within which everything needs to happen. Where are we on the timeline? And also, while you're at that, you could tell us whether at this stage anyone is proposing to join the petition, and can they do that?
Right, Joe, we're on day 5 of that 14-day countdown. So tomorrow is the deadline by which the 3 respondents, IEBC, the chair of IEBC, and the president, Uhuru Kenyatta, must file their answers to the Supreme Court. They had 4 days to do that, so that deadline expires tomorrow. That's Thursday. So day 5. After that, then Friday, you've asked a question about can anyone who may want to be part of this petition do so? They can. On Friday, file an application seeking to be enjoined to be part of this petition. However, that application must be a maximum of 5 pages, according to the directive from the Supreme Court. Also, you could file an application seeking to have more information, either added to the petition or extracted from some of what already has been submitted, or even seeking a clarification. Remember, for example, in 2013, NASA Accord at the time had sought to add a 900-page affidavit. Of course, that was kicked out and the judges cited out of time being an issue. But this Friday day 6, is one that all manner of applications, including those that have mentioned, could take place, Joe.
Okay, and what about civil society? Are they joining this case at any point?
Civil society, that's a good point, because I have with me in studio the Executive Director of Africa, that's Africa Center for Open Governance, Gladwell Otieno. She was a petitioner in the 2013 petition. They were consolidated. There were 3 petitions in total. And we want to find out from her that, because there's been a lot of speculation around whether they would be joining, why they did not join as petitioners themselves. So Gladwell, thank you for joining us here on KTN News.
Thank you.
And so you clearly are not petitioners in this particular 2017 presidential election, but do you intend to join file an application to join the suit?
You know, quite over and above the sort of political gossip about will they, won't they, we have substantive reasons for why we first in 2013 engaged in the very onerous task of putting together a Supreme Court presidential petition in 7 days with largely voluntary efforts. And our interests were focused on the process of the election, on the conduct of the elections, on whether those elections met the constitutional requirements. And unfortunately, we think that the legacy of the Supreme Court judgment is one which is very narrow and which does not lead to the full flowering of the new constitution. Indeed, it's a very restrictive approach, which places the burden on the petitioner to prove not only beyond reasonable doubt that there was criminality or illegalities involved, but that these impacted on the results. And what we're saying is the problem is that the elections, we must have elections which fulfill the constitutional requirements, free, fair, credible, etc.
But who should prove that if not the petitioner?
Actually, the IEBC is the body which has been charged and mandated and resourced to make sure that the sovereign will of the Kenyan voter is protected and fulfilled. Unfortunately, we see the IEBC being allowed to not fulfill that and get away repeatedly with not fulfilling that.
So we're getting into the merits and demerits, which I want us to avoid, although you do have a problem with the sub judice rule as well that we're seeing coming from the Supreme Court.
We're talking about a subject of intense national interest.
Which the Supreme Court appreciates.
Which the Supreme Court appreciates, but we want to have a feeling that the Supreme Court is moving in a direction of opening itself to scrutiny, allowing public debate, allowing the constitutional values of participation, public participation, and to flourish, and of accountability. And this can only happen when there's debate.
But when there's debate before the petition is heard, isn't that premature?
Not really. I mean, it would be, we've been scrutinizing the elections. Civil society is not only engaged at the end of the process. We've been scrutinizing the pre-election environment and readiness for the elections. We scrutinize the conduct of actual election day, and we're scrutinizing post-election dispute resolution, and we will have something to say about it, so even though we're not presenting evidence in court. Therefore, I don't think we're bound not to discuss our findings.
As we bring this to a close, 2013, you were in the middle of it. You were part of the petition then. What lessons, if any, did you draw from that? Would you say judges, as they sit through this, the parties involved, need to keep in mind to just ensure there's justice at the end of the day?
I would say that if the Supreme Court does not reverse itself on key aspects of its decision in 2013, then the petitioners will have an extremely hard job, if indeed not an impossible job, of getting the elections reversed or invalidated or whatever it is they're seeking. It's essential that the Supreme Court revisit its, I would say, quite retrogressive judgment in order to allow us to arrive at elections which can be accepted as credible by all, so that we avoid this 5-yearly drama of elections bringing the entire country to a halt every 5 years.
All right, many thanks. Gladwell Otieno, Executive Director, AFRICOG. So, Joe, there you have it. And, of course, to just sum up in as far as the timelines are concerned, so Saturday is when we expect that pre-trial conference to take place, and many have argued on the same day, as well as from what we'd heard from the Chief Registrar of the Judiciary, the Supreme Court should be able to begin hearing. But remember, there's that question of whether the Chief Justice would then sit, because he'd indicated he would not, because he's a Seventh-day Adventist. So we'll have to wait. But we understand from our sources by Friday the Supreme Court will issue a notice giving the guidelines in as far as timelines and what will happen thereafter. Joe.
Oh, thank you very much, Sophia Wanuna. Sophia is on that case and will be here with us throughout this week as we look at this case, and of course rolling over to next week as the hearing proper begins. Now, Kakai, before we go down memory lane as we had suggested, Gladwell Otieno there says interesting things. What do you think was the impact of civil society getting involved in the presidential petition the last time, and are we missing out anything this time around now that they are not there, or are we just fine?
Well, I'm a bit surprised that civil society chose not to be enjoined, because when you look at the new rules that have been developed by the Supreme Court...
Someone said they were raided around that time. So
yeah, but when you look at the new rules...
For other reasons.
And I'll explain why. When you look at the new rules that have been developed by the Supreme Court, it allows anybody who is interested to join, to be enjoined in the petition, and so that window is there. I'm surprised that they did not apply, and I'm surprised that they are not going to be part of it. Because one of the most, they could also go in as amicus, because that is allowed under the law as long as you prove what you're adding to the value. But one of the things that the civil society will have done is to seek to be enjoined or to go in as amicus, and when they do that, then they provide policy in terms of what they think that this petition should, because they're basing their arguments on the 2013 petition. What is these philosophical issues and jurisprudence that has developed over the last 4 years since the last petition? It will have been a very good thing for the civil society to have been enjoined. They need not to have evidence to justify anything, but just lay basis, the way the Attorney General does, for the jurisprudence of the case.
All right, and we'll be discussing the role of civil society. I understand LSK is in fact seeking to be part of this case, but while the legal process of contesting a presidential election may appear quite streamlined, it wasn't always the case. Aggrieved losers of the elections had to deal with a broken system and an aggressive regime just to get their petition heard. Let's have a look at this story.
The Supreme Court of Kenya, the highest court in the land, whose decisions are binding and set precedent on all other courts in the country. Established under Article 163 of the Constitution of Kenya, one of the main reasons for the creation of this court was to hear the presidential petitions.
The seal has been affixed and it is presented to His Excellency the President.
Because the history of presidential petitions in Kenya had been grim. It began with the multi-party election of 1992, when President Moi quashed the opposition, garnering the majority of votes. A total of 6 petitions were filed at the High Court, but all 6 were thrown out on technicalities. For instance, businessman John Harun Mwau, who was on the 1992 presidential ballot, had garnered only 6,499 votes. In his petition, Mwau argued that he was the only presidential candidate who had been validly nominated because the rest of the candidates had presented their list of signatures on the wrong size foolscap. The court found the argument ingenious, but that it held no water. The petition that made headlines, however, was won by Kenneth Matiba, a man whom many believed could have been the front-runner in that election. He alleged massive rigging and ballot stuffing by President Moi's camp. But before the case could be heard, President Moi challenged the validity of Matiba's petition, arguing that he had not personally signed the petition. You see, Matiba had suffered a stroke at committee prison where he was detained by the Moi administration for his multi-party activism. He had lost the use of his right hand, and so his wife Edith, who held Matiba's power of attorney, had signed the petition on his behalf. The High Court's verdict quoted the law's provision that Matiba ought to have signed the petition in person, and that was the end of that case.
That I will preserve, protect, and defend the Constitution of Kenya as by law established. So help me God.
But even though Moi appeared to have the upper hand in 1992, pressure was mounting for constitutional reform. In 1993, Parliament voted for the Constitutional Amendment Act No. 62, which set the two-term limit for the presidency. James Orengo went to court in 1994 in a petition to challenge President Daniel Arap Moi's eligibility to vie for another term in office. This was the first litmus test for the Amendment Act. Orengo argued that the act needed to apply to Moi because he was already on his third term in office. The court disagreed, stating that the act would be applied progressively. It would apply to President Moi after the next election in 1997. 1997, enter the next crop of opposition leaders, Mwai Kibaki, Kijana Wamalwa, and Raila Odinga. With a divided opposition, Moi was able to clinch 2.5 million votes against Kibaki's 1.9 million. Kibaki dashed to court and argued that the election was not free and fair, but the case could not be heard. President Moi argued that he had not been personally served by the petitioner as stipulated by the National Assembly and Presidential Elections Act. The court ruled that Kibaki ought to have served Moi personally. So with that history of presidential petitions thrown out on technicalities, the 2013 presidential petition was the first to go to full trial under the dispensation of the Constitution of Kenya of 2010.
All right, quite some checkered history there of presidential petitions. And Linda, we were talking about this earlier, and one of the things that came out, I think, was how a lot of these were dismissed on technicalities. But I've heard people say, well, even after the new constitution came into effect in 2013, there was a technicality that threw out Court's affidavit at the time, something that many legal minds thought, well, maybe this could have changed something in how that petition went. So where is the weight of this justice question when we are talking about petitions of such weighty nature as a presidential petition with regard to what the technicality of the law is and the quest to find justice in a case like this?
Obviously, Joe, when you look at the 2013 presidential election petition, on the question of the technicality, you have to weigh it against two arguments. One, of course, our Constitution says that justice should be served without undue regard to technicalities that would actually defeat the cause of justice. Mm-hmm. Then you have the arguments that were proffered by the lawyers for President Uhuru at the time, stating that if you present them with a 900-page affidavit after you've already filed your documents, then there's a sense in which it skews their ability to be able to go through these copious amounts of documents in good time and respond in good time. So in their view, that already tilts the playing ground in favor of, the petitioner. So the arguments swayed the court at the time. although, of course, there are many, again, who argued that, nonetheless, the 900-page affidavit ought to have been, admitted if at all it was going to be able to, again, serve the cause of justice by being able to, show the truth or otherwise about that particular election. So I think there are two arguments to be made in respect of this argument of technicalities.
But let's go down memory lane, Kakai, and for instance, we have John Harun Mwao coming with this whole idea of the size of the foolscap. And at the time, the court said, well, good idea, but not good enough.
One of the things that makes us proud as Kenyans is that we are a very litigious nation. We like litigating. And when you litigate, you realize that it always adds to reforms in the country. When you look at the petitions and the history that has been narrated there, which is completely excellent, you realize that all those petitions, the Matiba, Matiba Moi, Aaron Mwao, James Orengo, and Mwai Kibaki, had some fundamental relationship to what came to happen much later in terms of reforms. Mm-hmm. So,
yeah, let's talk about that. Like, what can you point out and say, well, because we had this problem,
exactly,
these are the changes we made?
Exactly. Now, let's look at the Matiba versus Moi petition, which was the first petition. You remember this was
the signing bit.
Yeah, the signing bit, which was very highly litigated. Mm-hmm. And remember that those 4 petitions happened under the old constitution and the old electoral reforms. Now, the issue that arose in Matiba was lack of signing the election petition by the petitioner himself. Yeah. Because that time, the constitution and Rule 4 of the Electoral Commission that time, electoral law that time, required a petitioner to file the petition himself. Matiba was incapacitated. He couldn't sign it. And therefore, it went to at preliminary stage, it was dismissed. Now, when you look at it, what happened in 1992, and compared to what happened post-2010 Constitution, you realize that now the issue of personal service has completely changed, in the sense that right now, a petitioner might not sign it, his lawyers can sign it, or if they sign it, it has changed. So there has been reform.
But there's a question there, like how much latitude does the court then have to make discretionary pronouncements on issues like that? Because surely everybody knew at the time that Kenneth Matiba had physical challenges that would have prevented from. What is that latitude that the court would have to make pronouncement based on objective circumstances that everybody can see, regardless of what the letter of the law might be?
As my colleague has said, there have been changes that have been made since that time till now. For instance, I would consider one of the key changes to be that have happened within the judiciary. So, for example, the establishment of the Judiciary Committee on Elections has served to educate litigants much more today about, how to go about an election petition, educate the public and educate everyone. And to date, the Judiciary Committee on Elections, I do know, has done quite a lot with respect to documenting procedures. We've seen, for example, the Supreme Court releasing practice directions the other day that parties must do this on this day, must do this on that day. So we've got a better educated public, including litigants, with regard to the steps that must be taken during filing a petition. Of course, one other change that has come today is the pretrial conference, during which time the Supreme Court, together with the litigants and interested parties, as well as amicus and other people, can be able to establish, ground rules about various things. So I would say that the clarity that there is today is certainly what was missing at the time. And of course, the spirit of the 2010 Constitution, which largely, establishes the philosophy of this nation today, which is to lean more towards justice than technicalities.
Yeah. Do you agree? I
do agree.
Gladwell there was complaining about even where we are now. Including the direction that have been given today by the Supreme Court, that there's still all these strictures that we keep seeing from the courts that, well, there's what the letter of the law says, the technicalities of it, but also this substantive issue of justice.
No, I think the issues of technicality, we Kenyans, we have to complain. Almost on everything and anything, although we have done a lot of terms of reforms, the issues of technicalities has completely been dealt away with by the Constitution. And so it's not even an issue anymore. because in any event, the Chief Justice has the power and authority to keep on redefining the rules that operate under the Supreme Court, because we have the Constitution. That Constitution must marry into the Supreme Court Act, and the Supreme Court Act must produce the Supreme Court rules. And these rules are debated and discussed amongst the judges, and they agree that these rules are the ones that are governing us. But the spirit of the rules is not to try as much as you can to avoid what? Technicalities. But when you look at one of the other fundamental things, that the James Orengo petition in 1992, I think the mother of all this was the James Orengo petition. And when you look at the James Orengo petition in 1992, he moved courts and said that, look, President Moi has ruled 15 years already, from 1979 to 1992, and now that we have multi-party and we have Section 2A removed under the old constitution and we are now in a new democracy, President Moi should not be allowed to run for another term. That was the contestation in the Orengo petition. What did the court say?
The 94 about term limits, yeah.
Yes, at that time. What did the court say? The court said, no, look, it went to the Court of Appeal, and at that time the Court of Appeal was the apex of the court. There was no court, the Supreme Court at the time, and the court said, no, the law was created not to act retrospectively, and therefore the future is to think about it. So the question is, what did that lead to? In 2010, we now had that thing enshrined in the Constitution, where now a sitting president should not serve more than 2 terms.
Yeah,
so this has been reformed.
And we'll be talking about that whole idea of retroactivity in a few moments. But first, we need to take a short break. You're watching